At the same time as the surveys were being conducted, legal opinions were requested and obtained from 3 law firms, 2 of which represent major denominations and are familiar with ecclesiastical operations. The questions that were posed to these law firms were the following. Can the Executive Committee remove both regular and ex officio members of the Executive Committee for cause? If the answer is yes, by what percentage vote margin? Second, does the power to remove also include the power to discipline in other ways? Third question, do the bylaws authorize the Executive Committee to impose additional sanctions such as the loss of voice or vote? And finally, can the Executive Committee establish disciplinary penalties and procedures to impose on its members that the Constitution or bylaws do not specifically authorize or provide for? In summary, the 3 opinions unanimously opined that 1, the plain language of Article 13 of the General Conference bylaws provide that the Executive Committee can remove for cause any member without limitation, including ex officio members, by a 2/3 vote, by a 2/3 majority vote, for the reasons stated and outlined in the for cause section of the bylaws. Secondly, the rights of members of associations such as the General Conference, which is an unincorporated association, including the process and criteria for becoming a member and for terminating that membership, are set forth in the Constitution and bylaws of the association. Neither the Constitution nor the bylaws mention the removal or denial of voice or vote as a form of penalty to be assessed against a committee member. Where the proposed discipline impacts the fundamental rights of a member, including the taking away of voice and vote, sanctions or discipline should be specifically set forth in the governing documents of the unincorporated association or in the rules that the organization has adopted. The General Conference governing documents and policies do not provide for such discipline, and as such, they recommended that wording should be incorporated into the governing documents before such discipline may be used against members. Number 3, the bylaws appear to allow for the removal of an elected official or member of the committee for belonging to a constituent group that persistently disregards voted church-wide policies or decisions. That would qualify as a for-cause basis for removal, and U.S. courts would it be extremely unlikely to even entertain a challenge to the Executive Committee's good faith decision on that basis. To be clear, the governing documents do not call for spiritual or intellectual agreement with these policies and decisions, but they do require cooperation from members after they have been discussed and voted. The bylaws describe a violation as a persistent failure to cooperate, and the remedy of removal for cause would occur if the Executive Committee member distinctly demonstrates that they do not intend to cooperate. Finally, number 4, an officer or member of the Executive Committee whose constituency disregards a General Conference determination despite the officer's best efforts to ensure compliance or to lead an appeal process while ensuring compliance, regardless of the officer's personal beliefs, would not likely meet the prerequisites of removal for cause according to Article 13, Section 1C. Those were the summaries of the legal opinions that we obtained. As a result of those opinions, the Unity Committee then began to work on the document, taking into account the opinions that were obtained, and to refine the available options for noncompliance to be in compliance, to be in line with the options that were received, the opinions that were received. From the work that was done by the Compliance Committee, that is the document that is before you, after outlining the due process to be followed, and if compliance was not achieved, the document then goes on to outline 3 proposals for discipline against the organization or the duly elected leader of that organization. In summary, the organization or leader may be subject to one of the three disciplinary options: warning for the organization, public reprimand of the elected leader of the organization, or application of current policy or governing documents to implement a removal for cause. None of those three options, nor the process outlined, violate either the spirit or the text of the Constitution and bylaws of the General Conference. The bylaws require, and our practice has been, that any actions taken at meetings of the General Conference in session or the Executive Committee are to be done by or decided by a simple majority vote, with the exception of those provisions which require a supermajority, a two-thirds majority, such as amending the Constitution and bylaws, and any other specifically provided for sections, such as the removal for cause of officers, directors, and members of the Executive Committee. Even decisions of significance to the World Church, such as amendment of the fundamental beliefs, amendments to the church manual or working policy, the election of officers or departmental directors, are all decided by a simple majority vote. The provisions that are found in the document before you, when recommendations are made to annual council or the General Conference session, are to be dealt with according to the provisions that are found in working policy, the Constitution and bylaws, or in applicable corporate law. Finally, the document outlines disciplinary procedures in the event of the failure of due process. Two of the measures are warning and public reprimand. Reprimand is defined in the Oxford English Dictionary as a formal expression of disapproval, an official declaration to someone that their behavior is wrong and not acceptable. It is this type of punishment, in addition to expulsion and censure, that is used by legislative bodies to punish their members and others who have been guilty of some impropriety or conduct or improper conduct towards that body. For example, in the U.S. Congress, cases of reprimand are handled by a resolution adopted by a vote of the body. The Executive Committee, our Executive Committee, has in the past issued reprimands to some of its members for actions that they took part in. So in this instance, no new precedent would be set by doing so here before us. Warnings or reprimands are given or carried out by simple majority vote of the body, whereas when it comes to removal of a member for cause, the bylaws require a two-thirds vote. The fundamental rights of voice and vote are not being impacted by the warnings or reprimands. If they were, that would require a two-thirds vote. At this point, Hensley will take us through the policy sections.